more like the one that greeted the passage of the Administration of Criminal Justice Act in 2015. But days after that euphoria, observers are warning that this act should not just end in a change of name for the Nigerian Prisons Service. On the scale today, we shall be looking at the elements in the Nigerian Correctional Service Act which should make Nigeria truly excited and hopeful about the future of criminal justice in Nigeria. Welcome to the scale of justice. I am Femi Okeowo. A study of the Nigerian Correctional Service Act shows that with faithful implementation and funding, the signing of this act should go beyond a mere change of name. In today's program, we shall be taking a look at some of the special provisions of the act. Controller General of the Nigerian Correctional Service, Jafaru Ahmed himself, highlighted some of these provisions when he addressed top officials of the service recently.
You will all agree with me that one of the greatest challenges of the former Nigerian Prison Service and still currently the Nigerian Correctional Service is the overwhelming overcrowding issue. Overcrowding has become a very menace of the service. So the new act provides a statutory procedure for rejecting inmates on account of lack of space. Section 12(4) states, where the custodial center has exceeded its capacity, the state controller shall, within a period not exceeding 1 week, notify the chief judge of the state, the attorney general of the state, the prerogative mercy of the state criminal justice committee, and any other relevant body that is an interest. Subsection 7 states, upon receipt of the notification referred to in section 4, the notified body shall, within a period not exceeding 3 months, take necessary steps to decongest the facility if it must accept more inmates. Then, Section 8 specifically empowered the state controller of correctional service in conjunction with the officer in charge of the custodial center to reject more intake of inmates where it is apparent that the correctional center in question is filled to capacity. You will all agree with me, it has become a source of problem for the former prison service and still currently with the Nigerian Correctional Service that we still have this kind of problem. The next one that it addressed, I'm taking issues one by one of what it addressed and what is not in the former law. Prisoners on death row. We have so many of them. So many. They are filled to capacity of where we are even keeping them, and we are keeping them to where we are not even supposed to take them because there are many. The new act brought a succor and hope for the inmates on death row. Previously, this category of inmates live under the suspense and mental torture of death, which the appropriate authorities would neither sign nor easily commit to life imprisonment. Section 12(2)(c) of the NCS Act now provides that where an inmate sentenced to death has exhausted all legal procedures for appeal, a period of 10 years has elapsed without execution of the sentence, the chief judge may commute the sentence of death to life imprisonment. That means they are now being given hope. Then, there is a certain region within this country, a geopolitical zone, that is known of taking their mental relations into prison. They just go to a judge, get a warrant, and dump them in prisons. And that's the end. They have not committed any offense, but the law says, so long as you are accompanied by a valid warrant issued by a court of competent jurisdiction, there's nothing the prisons can do or the correctional service can do rather to accept them. But now the law provides to further humanize incarceration. The NPS Act now provides the use of correctional facilities for indiscriminate dumping of persons without due regard to their state of health and age. Section 13, subsection 3 states, a superintendent shall refuse to admit persons brought in with severe bodily injury and who is B, mentally unstable or is unconscious state of mind or underage. So we can now have the powers to reject those that we know are insane, because the correctional center or the custodial center is not a place for insane people. It's not a place for where people that have been battered by God knows, those who how he was arrested and be brought to a custodial center, and we are forced to receive him whether we like it or not, and whether we have the facilities to receive them. Then the issue of ex-convict syndrome, which is a problem. For all of us, we know that we are all members of the society. If one of our members or our family have gone to prison, everybody will not want him in his house. Some will continue to. So the issue, and the larger society also, and there is also the issue. So subsection 5 has addressed the age-long challenge of stigmatization as trained offenders who demonstrate high level of penance can now be issued a certificate by the chairman of the board or recommendation of the Controller General. This enables him to engage and compete for social recognition without toga of ex-convicts. It states, and I quote, "The Correctional Service shall provide opportunities for education, training in vocations, as well as training in modern farming techniques and animal husbandry." Section 5 reads, "The Controller General may recommend to the board for the issuance of certificate of good behavior upon discharge to an inmate who has demonstrated good conduct, including those who have acquired training through formal or informal education, aimed at facilitating their reintegration." And Section 6 provides that a person who is issued with a certificate of good behavior shall not be discriminated against on the ground of his custodial sentence. This is clear.
Over the years, many organs have called for the reform of the nation's prisons service. One of such organs, the Presidential Committee on Prisons Decongestion, which is headed by the Chief Judge of FCT High Court, Justice Ishak Bello.
We will soon resume and complete the visitations around some of the prisons. In the interim, we have made some recommendations for looking into by Mr. President on the existing bills for the reforms of the Nigerian prisons, where I was able to draw their attentions to some of the few things that I consider very pertinent. And I think it was very much an enriching program which I attended, and it is in line with the mandate of my committee to ensure the passage of these existing bills towards the reforms of the Nigerian prison.
As you go around, you find that there are some areas that the Administration of Criminal Justice Act has already settled, but which are not being observed. Some of them are possibly even administrative. Are you collating those ones different from the ones that you have noticed the law needs to deal with?
Yeah, you'll observe that wherever we went, we had the Attorney General and the head of court of that state.
Yes.
And where situation required, we drew attention of both the Attorney General and the head of court on what to be done or what to do. Like where I kept on saying repeatedly, where courts make orders remanding people on grounds of compensation. I drew the attention of the heads of courts, the Attorney General of the respective state, to the anomaly in that procedure. Because order for compensation, as I said repeatedly, can be realized by the manner you enforce judgment. You cannot have somebody out infinitum in prison without any definite period of exit. That was amounting to sending him for life imprisonment. Once he has finished the terms of imprisonment, you can't continue to hold him for order of compensation, or whether he has paid the fine. You can't hold him on account of order for compensation. We met a situation where somebody was convicted and sentenced, and I think you were there, to 3 years. Yes. What was the offense? Intention to commit a crime. That is not a crime anywhere in any penal provision, whether in the northern part of Nigeria or southern part of Nigeria. Intention to commit a crime without any express indicators regarding the expression of the intention practically. Already convicted. Luckily, the Chief Judge was there and the Attorney General was there. We are drawing attention because these are matters that constitute areas for in-house workshop to be organized by the respective heads of court, perhaps with the prosecutors side by side to correct these anomalies. The one case that stands out, you know, in one of the states that we met down south is where a high court judge has sentenced a woman to 5 years imprisonment and to pay a fine of 1 million. Now,